Hello everyone, my name is Yi Xiao. I am a patent attorney and Beijing Sanyo Intellectual Property Agency Limited. We are all familiar with amending the claims before and during examination procedures. But after the patent is granted, can we still amend the claims? If so, how can we do that? This is my topic today, amending claims in invalidation procedures. This talk is mainly in three parts. First, legal basis and basic principles. The second is amending the claims in the invalidation procedure. And the third part is a case study. So our first question is, can we amend the claims post-grant? The short answer is yes. But more specifically, we can amend the claims post-grant, but only in response to a request for invalidation. The legal basis first lies in Article 33 of the patent law, which essentially sets an information scope of any claim amendment, that is, not going beyond the scope of the original disclosure. Rule 71 of the implementing regulations assures us that we have the opportunity to amend the claims post-grant, but there is a limitation, or so-called the protection scope. In the course of the examination of the request for invalidation, the patentee for the patent for invention or utility model concerned may amend its or his claims, but may not broaden the scope of the patent protection as provided by Rule 71. Although we may amend the claims post-grant in response to a request for invalidation, there are some basic principles that we have to follow as provided in the examination guidelines, which includes the following. First, the subject matter cannot be changed. Second, the scope of protection cannot be extended with respect to the granted patent. 3, the amendment cannot go beyond the scope of the original disclosure. And 4, any addition of technical features not included in the granted claims are generally not allowed. It goes without saying how important timing is for us and the patent owners. Missing a deadline sometimes may just cost you some more money, but on some occasions could be fatal. It's all the more important always to be alert of the timeline for amendment during invalidation. In this pattern here, I outlined some important time points in the general invalidation procedure. Upon receiving an invalidation request, the window for amended claims is open. More specifically, within 1 month upon receiving the invalidation request transferred by the patent office, the patentee has the option of making all types of amendments that are acceptable during invalidation. But what are the acceptable amendments? Let's save that for later. In some circumstances, the petitioner may raise a new cause or evidence, and in that case, the patentee has another 1 month to amend the claims with all types of acceptable amendments. Then the oral hearing will be held and an examination decision will later be made by the re-examination and invalidation department. In addition, up until that point, that is, before the examination decision is made, the patentee can also amend the claims at any time, but by deletion only. So let's look at what types of amendments that are acceptable during an invalidation procedure. They can basically be categorized in 4 types. First, deletion of a claim. Second, deletion of a technical solution. Third, further limitation to a claim. And the fourth one is correction of an obvious mistake. Before 2017, there are just the first 2 types of amendments, that is, amendments by deletion, plus a third type, which is combination of claims or technical solutions. And this third type was replaced by further limitation to a claim after the amendment to the examination guidelines in 2017, which somehow gives the patentee more freedom. The first time here, correction of an obvious mistake is also ended at that time. But since this type of amendment is quite subjective and case-dependent, we will not go into detail of that today. So the first 2 types of amendments are deletion of a claim or deletion of a technical solution, which are what I meant by deletion only earlier. These are both quite straightforward and self-explanatory. Deletion of a claim means removing one or more claims from the claims. And deletion of a technical solution means that one or more technical solutions are removed from several parallel technical solutions in the same claim. The third type, further limitation to a claim, is a bit tricky. Let's look at the exact words in the examination guidelines. Further limitation to a claim means that one or more technical features recorded in other claims is incorporated in the claim, so as to narrow the scope of protection. There are some strict restrictions to this type of amendment. First, in terms of scope, it has to be within the information scope established by Article 33 and the protection scope as provided in Rule 71. Also, this type of amendment has to be made for the purpose of responding to an invalidation cause. As for the specific manner for this type of amendment, the Supreme Court indicates in the judgment in 2023 that the Patent Office should look into the following three aspects. One, whether all of the technical features of the claim to be amended are included in the amended claim. Two, whether technical features is added in the amended claim compared with the claim to be amended. And three, whether the added technical features are all from other claims as granted. Over the timeline and basic rules of amending the claims during invalidation. These may all become clearer to you after we dive into a specific case here. Invalidation case against the invention patent owned by Merck Patents with the invention title liquid crystal displays and liquid crystalline media with homeotropic alignment. To the invalidation request, Merck amended the claims within a month. Here is Claim 1 after the amendment, which was later accepted. The amendment was made by incorporating Claims 2, 5, and 12 as granted into Claim 1. 2, 5, and 12 were then deleted. It was made to dependent Claim 6, which was Claim 8 as granted, by further limitation based on features in dependent Claim 22 as granted. Essentially, the definition of R2 of Claim 22 was added. There is a substituent in the organic compound with the formula MES R2 defined in Claim 1, as you see. 19, which was previously Claim 22, that the patentee claims to be the basis of this amendment to Claim 6. Lined here is the definition of R2 19, and hence in the amended Claim 6. 6 depends on Claim 4. It inherits all the technical features of Claim 4, particularly the definition of R2, as you see here. Therefore, the definition of R2 here sets the protection scope of Claim 6 as amended, or previously Claim 8. You'll see a more direct comparison of the scope of R2 before and after the amendment. Clearly, you'll see that the protection scope of Claim 6, particularly the definition of R2, has been broadened. There are many additional groups as compared before the amendment. It therefore was not accepted by the panel in court session during the oral hearing. Amendment made by the patentee. Claim 4, previously Claim 27, was amended by further including the use of the organic compound according to Claim 19 to that of Claim 4, as you see as underlined here. Claim 24 here is actually an independent claim, and this amendment introduced by the patentee to adding a parallel independent claim. So the panel found this amendment unacceptable because the amendment does not narrow the scope of the claim and even introduces a new dependent claim. The amendment to Claim 6 and 24 was not accepted. Not yet the full story of this case. The patentee Merck Patent of deleting the amended claims 6, 7, and 24 in court during the oral hearing. Merck turned it down and said it was not acceptable because Merck did not provide the replacement sheets for that amendment. Cited Rule 52 of the implementing rules in appeal as the legal basis for this. The Beijing Intellectual Property Court, who upheld the examination decision, and later Merck appealed to the Supreme Court. The Supreme Court, however, found for Merck that the amendment by deletion made by Merck orally in court during the oral hearing was acceptable and revoked the examination decision. Given by the Supreme Court were mainly in two folds. On one hand, the examination guidelines clearly states that the patentee can delete a claim or a technical assertion included in the claim before an examination decision is made. When they given by the Supreme Court were mainly in two folds. On one hand, the examination guidelines clearly states that the patentee can delete a claim or a technical solution included in the claim before an examination decision is made. On the other hand, when the collegiate panel finds one or more claim amendments not acceptable, it should give the patentee the right to choose to either use one of the previous acceptable versions of the claims or to delete unacceptable claims and keep the remainder as basis examination, whether orally or in a written form, and whether or not replacement sheets are submitted in court session. From these cases, for amending the claims during validation, the approach by deletion is simple and relatively flexible. But when it comes to further limitation, you should be extra careful of when and how to make the amendment so that it may be accepted. All of my talk today. Thank you for hearing.